Hello, my name is Kevin Harrington, and I'm a co-chair of the Trust and Estates section. Welcome to Probate 101, Omitted Spouses and Children, Post-Planning Surprises. Before we begin, we have a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in the BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with your certificate. Our next program will be next week on July 19th by Geraldine Weil and Geraldine Cohen, discussing creditors' claims, do's, and don'ts. The Trust and Estates section is still accepting applications for positions on the executive committee. The deadline to apply is tomorrow at 5 p.m. If you're interested, please apply or ask any of the executive committee members any questions you may have. We have a few words of our sponsors before we start. The Sanborn team has been sponsoring the Beverly Hills Bar Association Trust and Estates section since 2006, servicing clients for over 35 years. The Sanborn team gives members and colleagues attractive results and peace of mind with a depth of knowledge of probate, trust, and conservatorship unparalleled in the industry. We also have a few words from Orit Gadish of Geffen Real Estate.
Thank you, Kevin. Have you ever had a situation when a beneficiary or family member has decided to live in the property for free and doesn't want to leave? Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate. We're a full-service firm. Not only do we help you with partial or full renovations, but we offer outside-the-box solutions for the difficult situations you may encounter when trying to sell real estate, such as when a beneficiary or family member has decided to live in the property for free and doesn't want to leave. I've worked closely with these occupants, negotiating with them, and successfully vacated the property without having to go through an eviction. We also provide squatter removal services for the stressful situations that arise when squatters decide to take possession. Feel free to reach out to me via text or cell. My number is in the chat box. Enjoy your program, and back to you, Kevin.
Thank you. In addition to the Sanborn team and Geffen Real Estate, the Trust and Estates section is also sponsored by Glen Oaks Escrow. Marcine Klein is a full-service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of Estates Act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that our clients are beyond happy with their experience at Glen Oaks Escrow. California Title Company. California Title Company provides comprehensive and timely title insurance, protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Lastly, Manufacturers Bank. Simplify your banking. Let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estates banking team with the excellence to handle all your banking needs. Contact Brian Flores, Vice President and Senior Relationship Manager, for more information. And for our program today, we are privileged to have our own David Shapiro and Nicole Torres discussing omitted spouses and children, post-planning surprises. David Shapiro is a graduate of University of Texas at Austin, University of California Law School in San Francisco, and Jerry Spence's Trial Lawyers College. He is a board certified in estate planning, trust, and probate law. He is the past president of the Los Angeles Estate Planning Council and currently serves on the executive committee of the Beverly Hills Bar Association. He previously served on the California Bar and Lawyers Association Trust and Estate Section Litigation Committee. He has also been selected to Super Lawyers for the past 6 years for his practice in trust and estate litigation. We also have Nicole Torres. She graduated from Harvard College. From there, she attended Cornell Law School and the USC Gould School of Law, where she graduated with her Juris Doctor degree. Ms. Torres represents beneficiaries, trustees, personal representatives, and heirs in trust and estate administration and litigation cases. I understand that David and Nicole have a great program for us today, and they will try to answer any questions that you may have at the end of the presentation by the Q&A chat box. I'll now turn the program over to David and Nicole.
Thank you, Kevin, for the kind introduction, and happy summer, everyone. This is for the 101 series. So the goal of the 101 series is basically provide the building blocks for new attorneys and experienced attorneys that are new to this practice area. And for this subject, I really want to not only provide those building blocks, but I also want to give experienced practitioners to the Trust and Estate section some more information on the topic and keep this interesting for experienced practitioners too. This is not intended to be an exhaustive recitation of the law on the subject, but we do have several goals. First, for new practitioners or practitioners new to the area, we want to assist you with the tools to practice in probate. We want you to understand some of the concepts that come up again and again on different areas in probate. And we also want to spark an interest in this area of law. So if you were interested in learning about probate and trust work, as well as trust and estate litigation, this would be I hope to make this a little bit more interesting and enticing for someone. Also, for experienced practitioners, this is intended to provide you information that will be helpful to your practice. Okay, Nicole, let's start.
Okay, so the applicable code sections are going to be Probate Code Section 21600 through 21623, and these are going to apply to all deaths after January 1st, 1998. More specifically, the code sections relating to omitted spouses are sections 21610 through 21612. And the code sections pertaining to omitted children are sections 21620 through 21623. And they apply to all property passing by will via a decedent's estate or by a trust that later becomes irrevocable upon the death of the settlor. Any reference to decedent's testamentary instruments will refer to either the will or the trust. However, it is important to note that estate as used in these sections is going to be slightly different than it's used in other parts of the code. Generally, estate refers to a decedent's probate estate. However, for the purpose of omitted spouses and children, an estate will include a probate estate as well as any property held in a trust. And I would also just like to stress the importance of reading the statute. It's a good way to, a lot of times, just reading the statute will answer any basic questions. And it's also a good way to get a general understanding and overview of this area of law.
Great, so the first question is, what is a surviving spouse? Basic answer is when a spouse dies, the survivor is the surviving spouse, and the predeceased spouse is the deceased spouse. The next question is, well, do you need a valid California marriage license to be a surviving spouse? And the answer is no, that's definitely not the case. California has very permissive rules on what constitutes a surviving spouse. For example, a putative spouse. A putative spouse is solemnized in good, solemnized in due and celebrated in good faith, but void or voidable marriages. So that basically means that someone that goes through a marriage ceremony and they believe in good faith that they were married, but for some reason or another, it's not, maybe there was no invalid marriage certificate, or there was a earlier marriage that didn't get properly divorced, maybe out of the country, and for whatever reason, it's a void or voidable marriage. Well, California still recognizes that and still allows them to be a putative spouse. So an example would be in the estate of Leslie, where the spouses were married in Mexico. They thought they had a valid marriage, but it was not recorded in Mexico. The courts held them out. They held themselves out as husband and wife. The courts held that out to be a putative marriage. And there's a basic public policy there to protect the expectations of the innocents and to achieve equitable, fair, and just results. And that's one of the key things in probate is that, probate comes from the chancery courts, which is basically the king's conscience. And the goal is to try to make a fair and equitable result for, and that's part of, the court's goal is to make things fair and equitable. So what about, let's see, what kind of protections does a putative spouse have? It's really the same as a surviving legal spouse, and in some cases, it's actually even stronger. So that case would be, an example would be in the estate of Hafner. That case where the first spouse, the first spouse they were married, and then the decedent abandoned them in California, abandoned her when they moved to California. They didn't speak afterwards. The putative spouse believed that they were still legally married after they had a marriage in Vegas, and even though they were not officially married. The decedent suffered serious car injuries. There was a large personal injury award, and what happened was the putative spouse was awarded one half the entire estate, and the other half was divided between the spouse and the 4 children. Other examples of surviving spouses are when you have a marriage overseas. Let's say you don't have a valid California license for anyone in the United States, but you have, you did have a valid marriage overseas, or even maybe a putative spouse from overseas. That's very possible. Registered domestic partners under Family Code 297, that's also a surviving spouse. Polygamous marriages, I believe, would probably constitute a valid marriage if the parties believed in good faith. So let's say that the marriage occurred in a different jurisdiction, like overseas in a country that allows polygamous marriage, and then they died in California, and the spouse in good faith believed that they were married. Most likely that would also be a surviving spouse. And Nicole?
So who is not considered a surviving spouse? This will be discussed in Probate Code Section 78, and it will be a surviving spouse who is a former spouse where the marriage has been dissolved or annulled. And this can apply to orders during the lifetime, but it also can be that if the decedent spouse passed away while a proceeding had began, as long as it was started during the lifetime, they could still no longer be considered a surviving spouse. However, it is important to note that only the spouse or former spouse has standing to seek dissolution or annulment. And this was evidenced in the case Pryor versus Pryor, which dealt with the estate of well-known comedian Richard Pryor. And in Pryor versus Pryor, Richard's daughter sought to annul her father's marriage to her stepmother on the grounds of fraud. However, the court held that she lacked standing to bring the proceeding because she was not the spouse. And also, legally separated spouse is not considered a surviving spouse, and David is going to delve into that a little bit further.
Right, so that's actually an interesting part. Under Family Code 78D, a legally separated spouse would not be a surviving spouse. However, in a case, Urban versus Contra Costa County Employee Retirement Association, 2017 case, the courts went a different direction. They said that a surviving spouse, for purposes of continuance pension benefits, includes a legally separated spouse. It said that no meaningful conclusion can be drawn from the probate code's definition because the substantive provisions of the probate code treat a legally separated spouse, at least as often as not, in the same manner as the surviving spouse, notwithstanding the probate code's general definition. What? I mean, that to me seems a little counterintuitive. The code says clearly that a surviving spouse, that they wouldn't be a surviving spouse, but then it says, well, we're going to ignore the statute. So that's interesting. So sometimes the code can be counterintuitive, and it's important to read the code, but also remember that sometimes the courts can ignore the code or take a different interpretation of the code, especially when there's inconsistencies in the code.
So the big question, what is an omitted spouse? Well, to qualify, you need to show 3 elements. First, that the deceased spouse had a will or a trust at the time of the marriage or registered domestic partnership. Second, that deceased spouse died without updating those testamentary instruments. And third, that the spouse did not otherwise provide for their spouse or registered domestic partner.
So it is the burden of the omitted spouse to prove those first three elements. If the surviving spouse can show those three elements, then there are exceptions to the surviving spouse, but that is on the beneficiary in the will or the trust to prove the exceptions. So the first of the exemption, the first exception to the omitted spouse is under Probate Code section 21611A. And that provides that a decedent intentionally failed to provide for the surviving spouse, and that intention appears on the testamentary instrument. So again, this is up to the person that's named in the instrument to bring out, and it's their burden to prove. And if they can show that, then they can make someone that would have been an omitted spouse, they would say that this exception applies. So under 21611A, it requires a certain level of specificity. There's a case called Estate of Axelrod, where it discusses the specificity that it needs to be clear that they were intentionally omitted. So a statement that the omitted that they omitted all not specifically provided in this instrument was not enough. However, in Estate of Duke, an exclusion that provided for all persons who become an heir by reason of marriage or otherwise did include sufficient specificity for 21611A to apply. Also, the question is, well, what if they were provided a nominal gift and then they got married? And the Estate of Poisel addresses that, and it says that providing for a person prior to marriage is not sufficient unless contemplation of marriage appears on in the testamentary document. So not only do they have to be contemplating the marriage, but that contemplation actually has to be shown in the testamentary document. So in the Estate of Lapidus, where there was a will that was executed 5 days before the marriage, which anticipates the events and names the and specifically excludes the wife-to-be from the estate, would be an example of that. And under that case, 21611A applied, and they were accepted from the omitted spouse statute.
Another exception is if the decedent spouse provided for their surviving spouse or registered domestic partner outside of their estate in lieu of in the testamentary instruments, and that intention is shown either by the decedent's statements, the amount of the transfer, or other evidence. However, this can be a difficult exception to prove. For example, we have the Estate of Shannon. And in Estate of Shannon, we had a decedent husband who left a significant gift in his California Highway Patrolman Fund to his wife, his surviving spouse. And in so doing, he also made statements to his former attorney that he had remarried, that his wife had her own money and more than enough, and that it was his intention that his daughter have his estate upon his death. On the face, it would appear that this might satisfy the exception pursuant to the statute, where he made certain statements, there was a transfer, and perhaps the exception might apply. However, the court held that it was insufficient to rebut the presumption, largely because it was not specifically clear that he intended for that gift to be in lieu of a gift in his testamentary instruments. So what does this tell us? It tells us that it is a difficult exception to prove, and that you need to be as specific as possible when trying to overcome it outside of a testamentary gift. And ultimately, the burden is going to be on the person objecting to the omitted spouse or the proponent of the will to show that any external transfer was in lieu of the testamentary instruments.
Okay, so the next exception is under Probate Code 21611C. And that is when a spouse or registered domestic partner validly waives the right to share in the decedent's estate. So what does it mean to be a valid waiver? Under the estate of will, a premarital waiver that meets the requirements under probate code sections 140 to 147 was a valid waiver, even though it didn't meet the family code provisions under 1615, which governs the enforceability of premarital agreements. So there's, it clearly does not need to comply with the duties, the level to enforce a premarital agreement. Now, the next question is, well, what about in between? And there was a case recently came down, Welch v. Welch, Court of Appeals case number B311507, Second Appellate District, filed May 31st, 2022. And that involved a mediated settlement agreement entered into prior dissolution that waived the rights to inherit under probate code section 145 as a complete property settlement. It was not an admitted spouse case. However, the settlement did constitute a waiver. And I would suggest that on such similar circumstances, something like that would most likely constitute a waiver. And the exception would apply most likely.
Another exception is the case of the care custodian spouse. So who is a care custodian spouse? It is a spouse who was a care custodian as defined in section 21362 of a dependent adult as defined in section 21366. And they will not be considered an omitted spouse if both of the following apply. If one, the marriage began while the custodian provided services to the adult, or within 90 days after those services were last provided, and the decedent died less than 6 months after the marriage began. However, if the surviving spouse care custodian can show by clear and convincing evidence that the marriage was not the product of fraud or undue influence, they can inherit. So this statute, it was added in part as a way to close a loophole that some less than kosher care custodians had discovered. And what they were doing was they were marrying their dependent adults to get around other caregiver statutes barring them from inheriting. So this was put in place in part to protect against that. However, it's important to note that it is not a complete bar, but the burden is on the care custodian spouse to overcome the presumption.
Okay, so now that we've discussed what a surviving spouse is and what an omitted spouse is, let's turn our attention to what a omitted spouse's intestate share of an estate is. And for community property under probate code sections 100A and 101A, upon the death of a person who is married or in a registered domestic partnership, 1/2 of the community property and quasi-community property belongs to the surviving spouse, and the other 1/2 belongs to the decedent. And then on probate code sections 641A and B, subdivisions A and B, the surviving spouse receives 1/2 the community property and community quasi-community property that belongs to the decedent. So in other words, they already own 1/2, then they get the other 1/2 under 641A and B. So in total, they get 100% of the community and quasi-community property. Since they already own one share. Next slide. So now that we talked about community property, the next issue is separate property. And under separate property for surviving spouses is under 6401 subdivision C. And it really depends on how many children there are and whether there are any parents, siblings, or issue of predeceased siblings that survive the decedent. So if there are 2 or more children, the spouse gets 1/3, and the other 2/3 is divided among all of the children and the predeceased children's issue. So 1 share for each child and 1 share for each predeceased child's issue. If there's only 1 child, or there's only issue of 1 predeceased child, then the spouse gets 1/2 and the child gets the other 1/2. If there are no children, the spouse gets 1/2. The parents and siblings and predeceased siblings issue get the other 1/2. And if there are no parents, no siblings, and no issue of predeceased children, no issue of predeceased siblings, and obviously no children, spouses get 100% or the entirety of both the separate property and the community property.
So what is community versus separate property? This can get more complicated, and we're not going to delve into it in great detail, but the basic presumptions are the following. The standard community property presumption is governed by Family Code Section 760, which states that except as otherwise provided, all property generally acquired during a marriage will be presumed to be community property. And this will apply to a marriage property purchased during the marriage as well. However, if property is purchased with separate property funds, then it might be separate property, although the burden is going to rest on the spouse asserting its separate nature to overcome that presumption. Now, what is generally considered to be separate property? This is governed by Family Code Section 770. And separate property will include all property of a person owned before the marriage, as well as any property acquired after marriage by gift, bequest, devise, descent. And this will also include any rents, issues, or profits of that property. Now, it's important to note with separate property that you have to be careful about commingling, because if funds are commingled or used to purchase an asset, it can convert that separate property into community property. So that is something to be mindful of.
Nicole, that was a much better and much more concise than when I learned in law school. So thank you.
Thank you. It's a basic rundown.
You nailed it in a very short and concise way. I really like that. Okay, so now that we've discussed the omitted spouses and intestate shares, let's turn our attention to omitted children. Okay, so 21-620 has two classes. Actually, 21-620 and 21-622 each have a class of what makes someone a omitted child. So omitted child under 21-620 is when the parent had a will or trust before birth or adoption. The parent died without updating the testamentary instrument, and the parent did not otherwise provide for the child. So it's similar to the surviving spouse one, but there are little differences, and we'll get into that. There's also Probate Code 21-622, and that there's not a similar analogous provision for surviving spouses or omitted spouses. For 21-622 is when a child is thought to have predeceased the decedent, or in cases where they believe the child to be unaware of the child's birth. So if they fail to provide for a living child because they thought they were dead or unaware of child's birth, they can be an omitted child. The child has the burden to prove each of the elements, both under 21-620 and under 21-622.
As with anything, more exceptions. So these will be governed by Probate Code Section 21-621. And some of these are similar to the exceptions for omitted spouses. However, there is an addition. So 1, the failure to provide for the child was intentional, and that intention appears on the face of the testamentary instrument. Second exception, and this is where there's a slight difference, is that if the deceased parent devised and directed the disposition of substantially all of their estate to the other parent, then the child will not be considered an omitted child. And third, if the child was provided for outside of the testamentary instruments and that intention is shown via statements or the amount of the transfer or other evidence. And there is less case law on omitted children than omitted spouses, but it's a safe bet to follow the guidance of omitted spouse case law when considering how to apply the exceptions for omitted children.
So if anyone's ever filled out a petition for probate or letters of administration, they always get the question about, has there been any children, stepchildren or foster children that would have been adopted but for a legal barrier? And that comes from Probate Code section 6454. And under intestate laws, when a stepchild or foster child was raised during their minority with the decedent, then there is a, and the child can show, the stepchild or the foster child can show that but for a legal barrier, they would have been adopted by, and they must show it by clear and convincing evidence, then they inherit under intestate laws under California. Now, it is not clear whether that applies to admitted children or spouses. So that's something that I don't believe I haven't seen any cases on point on that issue. And I think you can make an argument either way on whether or not a stepchild or foster child that would have been adopted, but for a legal barrier, would fall under under the admitted child. So next question is, what kind of legal barrier are we talking about? And they're almost always involved one scenario, at least from what in my practice is what I've seen, is that's when there is a second marriage and or some other relationship where the step parent would have adopted the child, but the biological parent refuses to give up their parental rights. So that is usually the legal barrier that that I've seen in my practice. I'm sure there might be other legal barriers as well, but that seems to be the most common legal barrier, is when the biological parent refuses to give up that parental right.
So once you've determined that someone is an omitted spouse or child, then the question becomes, how do you satisfy the share that is now to go to that person? So the first thing you would do is look to the testamentary instrument and determine if there was any estate or property that was not disposed of by the instrument. And you would look to that first and satisfy the share from there. This may not apply, though, if the will or the trust provided for a residue. So if that is the case, then you'll have to go on to the next step, which will be providing for that share from what was already bequeathed to other beneficiaries. And in this case, what you will do is you will look to the shares given to beneficiaries in proportion to their expectancies, and you will determine that using the date of death values. So the percents that each beneficiary and omitted spouse or child will receive will be based on proportional expectancies as valued at the date of death.
That's interesting. So it's not the date of distribution with the valuation to determine the distribution portion, it's the date of death. That's interesting. Yes. Okay, so the next question becomes, what happens when it would frustrate the obvious intention of the settlor or the decedent to divide up the gift or to break up that gift? So if they're entitled to, if the surviving spouse is entitled to 50% of dad's watch, and dad wanted to give the watch to his son, and it's a family heirloom, well, that seems like that would break up the obvious intention of leaving the watch to the son. So the court can apply an exemption for apportionment of a specific gift or device and adopt a different apportionment. And what are the kind of situations that would apply? So obviously, like dad's watch or mother's engagement ring, that would certainly warrant at least a discussion or some kind of bringing to the court that issue, because that would clearly that would be an obvious intention to leave a certain thing, a family heirloom, to a child. Another thing that would be, let's say you have a baseball card collection. Would you break up the baseball collection? That's a question. I don't know. Or let's say you have a business, an operating business that's been run in the family for a long period of time. How do you apportion that? Does the wife get half of it? Would that break up the obvious intention? Maybe the wife gets half of it. Maybe the wife gets bought out that half of it. Hopefully, that's something that the parties can reach an agreement on and come into a written agreement, and the court can approve that agreement and go that direction. If they cannot reach an agreement, then it's important that the fiduciary, the executor or the trustee, petitions to the court and asks for instructions on what to do on that. Because if you cannot reach an agreement, the fiduciary should go to court and request instructions.
So what does all this mean when it comes to estate planning? And as we know, whenever estate planners get in trouble, it's a problem for everyone. And that's what we saw in the case of Hire versus Flagg. And forgive me if I'm pronouncing that incorrectly. But what happened here is there was a cause of action in tort against an estate planner, where the decedent mother had informed the estate planner that she wanted her estate to go to her daughter, that she would be marrying soon, and the planner did not include that intention clearly in her estate plan. But not only that the planner had failed to advise her until her death to update the instrument. So what does this tell us? What can we learn? The key is specificity. And as a planner, it is critical to make sure you are aware of your client's intentions, that you're aware of these omitted spouse and children statutes and their effects, and ensuring that that intention is very clear on the face of the instrument. And not only when you create the instrument, but informing your client that if circumstances change after, that could have an effect on the instrument based on intentions that you were where they had, informing them of that obligation so that they can update accordingly.
Whenever the estate planners get sued by the kids, it's always a learning lesson. So hopefully we learn that lesson and we don't make those mistakes.
Exactly.
Okay, so the question then becomes, how do you enforce your rights? How does the surviving spouse enforce their rights? How does the omitted children enforce their rights? And how do the people named in the instruments enforce their rights or claim their exceptions to the omitted spouses and omitted children statutes? And it really depends on whether or not it's a trust or an estate. For an estate, that's probably where we should start, okay? Probate Code 11700 allows any interested party to bring a petition to determine entitlement to the estate. And that must be brought before the order for final distribution, but after letters for a general representative are issued. So in other words, the letters of special administration wouldn't qualify, but after letters of administration or actually would be letters testamentary, because this would be a testate decedent. So after letters testamentary are filed, then but before the final distribution, that's when a surviving spouse can bring their petition, or an omitted child can bring their petition claiming to be an omitted child or omitted spouse. And once they file that, then the person named in the instrument that wants to contest it can bring a probate code section under probate code 11702. Any interested party can file a statement of their interest in support or opposition of the petition. So someone can file a statement of interest acknowledging that interest, or they can contest it. And that would be the proper time for a beneficiary to raise an exception saying that they're not an omitted spouse or they're not an omitted child. A will contest would really not be appropriate because you're not really contesting the will. You're just saying that under the will, this person is a omitted child or omitted spouse, and they have certain rights. Now, the will or the trust is still going to govern as far as who's the trustee or who's the administrator. Whoever's listed in those instruments are still going to be the same person, but the spouse or the child will be able to enforce their interest that we discussed earlier that they would have. So that's for an estate. The other issue is for a trust, okay? And the best practice for that would be a 7200 petition under 21610. So 21610 is the omitted spouse, grounds. And I provided a sample petition in the material. So if you want to take a look at it, you can. I did ask for attorney fees on because the courts found that it might go against the testator's wishes to require a spouse to pay their attorney fees to enforce that kind of right. So you should take a look at that and you can read the case on that matter. But the 7200 petition, one of the key things is you need to have standing to bring a 7200 petition. And only trustees and beneficiaries may petition the court under 7200. But a beneficiary has a broad definition. That's a person who has any present or future interest, vested or contingent. That's under Probate Code 24C. And so saying that you are a omitted child or omitted spouse, you would have a vested interest in the trust. So you would be a beneficiary, even if you're not named as a beneficiary. Now, there's nothing in the statute that sets a time for it. So when should you file your 7200 petition? And I think it's best to file that within 120 days, not because I think there's a bar necessarily to bar you from filing at a later date, because the 120-day provision under 1606 1.7 really applies to contesting the instrument, and you're not really contesting the instrument. What you're really saying is that under the instrument, you're a beneficiary. So it's not a matter of that. But the issue is the trustee, after that 120 days, may start making distributions, and that might affect your interests. So I think the best practice for a omitted spouse or omitted child in a trust would be to file their petition within that 120-day period. Another approach could be a spousal property petition, and that's a summary proceeding where a spouse claims that certain property passes to them as community property or separate property from the decedent. And it's not, everyone should get notice of those proceedings but it's a summary proceeding, and most courts may be reluctant to provide for that to be the procedure to have the litigation on these surviving the omitted spouse and omitted children. And but however, keep in mind that if there is a court order in a spousal property petition under res judicata, that would probably apply. And if they're a omitted spouse under the spousal property petition. So I think that's something you should be watchful of, but also it's something that maybe wouldn't be the ideal way to go under certain circumstances. So a will contest really would not be a proper place to do it. And if someone does file a 7200 petition, a person named as under the will or under the trust could then file objections to the 7200 petition and claim that no, they're not an omitted spouse or child because certain exceptions apply. Okay. How are we on time? Oh, good.
We're good. Are you able to see the questions, David, or
let me pull them up. Let me see if I can. Hold on. Ooh, can we have the 2022 waiver site again? I'm gonna put that in the code. And no relation to Janet Shapiro. I haven't met you yet, but nice name. Second, from Janet Shapiro, where a child, his spouse, and issue are intentionally and expressly omitted, is that provision enforceable? Or is there an argument for challenging that by the child? So the question then becomes the specificity. So I think I discussed that briefly under the surviving spouse provisions. And let me see if I can pull up the case I cited. Hold on.
I think I can go back to the slide for you. Let's see. There we go.
Right, thank you. Okay, so the estate of Axelrod talks about the specificity, and also the estate of Duke also talks about it. So in the estate of Axelrod, again, it was a statement saying that they admitted all not specifically mentioned heirs was insufficient for specificity. But in the estate of Duke, when they talk about that all spouses or otherwise not provided for, any future spouses or otherwise not provided for, they found that to be sufficient. Okay, and I'll get you the site for that recent case in 2022. And next, let's see, for Margaret Norman. If a petition under 7200 is timely filed and then probate is opened, is it necessary to file anything to, other than a creditor's claim? That is interesting. So the question is, in the estate, you also need to file a petition for a entitlement to the estate. And I think really, if you have a order in the estate case, you can enforce that order in the probate case, and maybe you can post that order in there, or I mean, you can lodge the order and give notice of the court of that. But I think most important is if there's a petition for final distribution and there has been no determination yet about whether or not someone's an admitted spouse or an admitted child, absolutely should file your petition to determine entitlement prior to that hearing on the petition for final distribution. So I think that would definitely be the best practice. Okay, and I will get the site for the 2022 case. Give me a second. That was Welch v. Welch, and I'll put that in the chat bot. Okay. And from Susan Abraham, is it effective for a man to intentionally admit any and all children he may have fathered in the past or in the future after his documents are signed? So I guess what you're saying is, like, let's say you have a trust or a will, and the trust or the will states that any children born after the instrument is intentionally disinherited. And I don't know if there's a case directly on point as far as a omitted child, but there is that case I mentioned in the state of Duke. So I would lean towards it being an effective provision to prevent the exclusion of I guess it would prevent the child from, it would prevent the child from inheriting. So yes, I think that would probably be effective. So anyway, I believe we're about out of time. And if you have any additional questions or you want to discuss this any further, I did include on the last slide the emails for Nicole and I. So feel free to send us any emails with any questions. And other than that, thanks for coming out and enjoy the rest of your summer.